Hello, everyone, and welcome for this new webinar called The Next Chapter of Data Privacy. Let's wait for 1 minute for everyone to join, and we'll get started. Hey, welcome, everyone. I'm Romain, co-founder and CEO of Didomi. Thanks for joining. It's going to be hopefully a fun session. We have great guests today because I have the privilege to welcome our two speakers of the day, starting with Marie. Hello, Marie. Can you please explain us what you do at Piano? And yeah, we're glad to have you with us.
Hi, everyone. Thank you for having me, Roma. My name is Marie. I'm Global Senior VP of Analytics at Piano. I've spent the last 25 years in data and analytics, and I really believe in the power of data. And that's what we do at Piano. It's really privacy-first data and analytics to help our clients make smarter decisions every day. That's me.
Nice to have you with us. Hello, Max. Thanks for joining. I'm not sure you actually need an intro anymore, but maybe there are some people in the audience who are discovering you. So I'll give you the floor and the mic to introduce yourself and what you're up to also these days.
Yeah, my name is Max Schrems. We're basically running noyb, this logo in the background, which is a nonprofit organization to basically enforce user rights. So it's kind of like a consumer rights organization for GDPR in simple terms. And yeah, that's what we mainly do. And for the people that already know all of that, I can add that I like snowboarding, for example, to give some new information about myself.
Beware of sharing the personal information.
That's already out there.
It carries some risk. Thanks, Max. So today we have a fairly rich agenda for this discussion. But before we get started, I'll tell everyone that this session will be recorded, so you can watch it back later if you want, or if you can't attend the full session. The format is also a live discussion with the following topics in mind. We are also open to questions that can be addressed through the question tab. Please send any question that you have, and it will feed nicely the conversation. Also, there is a chat if you need to react or discuss with your peers. It's, as I said, intended to be live and lively. So please don't refrain from contributing. Okay, so a rich agenda, as I said, and we'll start with a very interesting topic that we call data sovereignty, that we framed as data sovereignty. So I would say that we've seen the theme of data sovereignty develop over the past couple of years with the data privacy framework replacing the privacy field and regulating the data transfers between the EU and the US. I would say, obviously, with the Trump presidency in the US, a lot of professionals, and especially privacy professionals, a lot of companies are wondering what will happen next on this critical question of data transfer. So I think that's the first interesting item to discuss. And this comes at a time where we can see that enforcement for GDPR and e-privacy against the US companies is continuing, and some people are even saying that it reinforces the dangerous narrative in the US that GDPR is an EU weapon directed towards US companies. Even though, as we can see on the screen, it's not only directed at US companies. A lot of EU companies are also being enforced. A lot of Chinese companies are also under the radar. So we can say there is a lot of equality in the enforcement. But still, I think there is this theme that is going on. And what we can first say to everyone listening is that there are ways to prepare on this important data sovereignty theme. And for our guests, my first question, probably for you, Marie, an opening question. I would say, like Didomi, Piano is a company that cares about privacy and also serves clients on both ends of the Atlantic. What is your take on this data sovereignty theme? How do you approach it at Piano? Because I think you have a very unique way of working on this topic that is worth sharing with the audience.
Indeed, thank you very much. So, I mean, in the previous slide, we've seen those fines. So when DPF happened, we thought, okay, we can transfer data to the US and, the end of the fines, etc. That is not the case. Even recently, I mean, even just last month, we've seen a large European bank being fined for not just consent related. It can be not observing the user's right to access the data, delete the data, port the data, etc. And I know we have audience from stateside. Let's not forget that in the US, especially healthcare, HIPAA entities are being fined millions and millions of dollars since the FTC and HHS sent that warning letter against using tools like pixels from Meta and Google Analytics without having that HIPAA compliance and BAA agreement, etc. So this is still very, very much the hot topic, and our clients are needing to do a lot of due diligence. But from Piano perspective, we are here to help our clients to collect the right data and use that data to provide better services to our customers, and make the difference in the bottom line in their business as well. So there are a number of things that we see on the screen here. Make sure that you assess the risk assessment, but also looking at competitive advantage. Many companies, especially for example in Nordics, they just go into consent only. Without consent, we're not going to collect the data. But you've seen the latest announcement from even in ICO in the UK, saying that you can collect the data as long as you can limit the purpose, as long as it's audience measurement, as long as it's to really get the statistics on how your users are using your website and how they are interacting without getting into that person information. So there are ways of collecting the information. So when you assess, I would really urge all of you to assess, do we have that consent collection methods and framework where we first, perhaps tier one, let's collect the data anonymously on an aggregated level using this exemption that is approved by many DPAs. And then we, if we are to expand that purposes from just collecting the data for statistical purposes, but you want to use that for marketing, advertising, you do need to have that extra layer of consent. So it has to be the consent-based marketing. So I will urge you to do this assessment to make sure you're doing the right thing in terms of due diligence, but also not losing that competitive advantage, leveraging exceptions, for example.
Thank you, Marie. And I think the exemption question is a critical one. And yeah, maybe Max, before you talk about this exemption idea, what's your take on the weaponization of privacy between the EU and the US? Is it something that is worrying you and that you see as something that we could somehow avoid or fight because it's going to do a lot of damage, I guess, for privacy in Europe.
In our experience now, the last half a year was interesting because, I mean, to stay with the topic of sovereignty and so on, as we wanted to, it has shifted in our experience a bit away from just this EU-US topic, from a general question about globalization. And I mean, that's much more than bigger than privacy, much more than anything we do in our daily lives. We now see this move towards like nationalization and building walls in all different ways, trade walls and so on. So it's interesting that in our, or in a lot of speaking engagements I have, for example, it shifts a bit just from the pure GDPR compliance question into the larger question of where does our data go? Can I trust that? So interestingly, to give you an idea, after Trump came into office, I was suddenly invited a lot to Denmark. And I was like, why am I invited to Copenhagen all the time? And turns out that that was still the discussion where Greenland was like in the focus. And, we keep forgetting that, but each 2 weeks, some of these topics come up and go away. And there was a feeling apparently that a lot of the data was moved into the US cloud. And for example, Trump, as a retaliation, could just embargo Denmark overnight. And that would mean that all Googles and Microsoft would have to shut down all customers in Denmark. Not anything that I think is likely to happen tomorrow, just to put it in perspective, but it became thinkable. Like, it used to be unthinkable. Now it's a possibility that we cannot rule out. And it's interesting that that goes beyond just privacy compliance. That goes towards still being able to operate your business. So I was joking, there is like, Maersk is one of the biggest container shipping companies globally, a Danish company. If they would be shut down tomorrow, they would literally not know where their containers are anymore, like, because their servers would not be available in that, in that scenario. And it sounds a bit weird until you realize in the first row, there's like the local military being like, yeah, that's why we're here at this conference. So on the data sovereignty discussion, again, being a globalist on my side and believing in the rule of law and international relations and, sticking to international law that we have, the reality is right now going a bit in the opposite direction. And to now connect that back to our privacy discussion, what's interesting is that this transfer agreement that we have with the US specifically, it was always a bit of a house of cards, in the sense of like, it's based on an executive order that Biden has signed. Well, we hope everybody complies with that, but we know that Trump can overturn it tomorrow. So when Trump got elected, I was actually behind this wall. There is my desk at the office. And I was sitting here until I think 1:30 in the morning with a bottle of wine, and I had to literally empty the whole bottle of wine because you had to listen to all the crazy, because there was the talk that he's going to overturn all the Biden executive orders that night, which would have meant the next morning we would have woken up and there would have been no legal basis for data transfers anymore. And that's a very interesting situation we're in. So I think if we talk about all of that, there is a bigger question about, I don't like the word sovereignty all that much because it's also kind of nationalistic in the thinking that it generates, but like baseline safety, where you know where your stuff is, and where if shit hits the fan, as the Americans call it, that that you still are able to operate and know where stuff is. And that's a bit of a different world now that we're in than, let's say, a year or 2 years ago, where it was mainly a compliance question about, okay, is that legal or not legal? Now it can become a much bigger topic for especially certain industry sectors. Obviously, everybody has a bit of a different scenario there. But that is interesting because a lot of these discussions move to much more fundamental questions oftentimes.
I agree. And zooming in a bit on the DPF and none of your business position on it, like I saw you recently say that if the DPF was changed again by the EU Commission, the result could be different. Is it something that is like kind of cooking at none of your business? Is it something that you're also like examining and working on? Because
Yeah.
I think like, we can't say we won't see that coming. I think it's
So
the elephant in the room.
So just to put in perspective, it always sounded like, oh, you just challenged that. The reality is the Schrems 2 challenge, for example, cost around 10 million euros, and I was personally liable for that. So just, a lot of that is a bigger enterprise. And
I didn't know we were so rich. Like,
yeah. First call I had was like, is this enforceable in Austria? And then the foreign ministry told me no. So I was like, okay, I'm not going to have a summer house in Ireland. Also good. Not the nicest place for summer houses. But anyways, no, to be serious, this is a bigger exercise. And one problem that we have to a certain extent is that the Latome case is pending right now. And it's very hard to get a reference through any other court as long as there's something pending at the Court of Justice. So we don't know if Latome is appealed or not appealed. We'll see. But we're a bit worried because after the first instance decision, it's a bit of a dead horse. So if that horse is kind of like ridden further, the Court of Justice cannot change the facts. The General Court has had really bad findings on facts because they basically said, we just believe anything the Commission has written in their recitals because nothing else was actually put in front of the court. So it's that reality. And I still think that Latome probably doesn't have standing to bring this case, and the General Court has not addressed that issue. So even if it would reach the Court of Justice and the Court of Justice would tell the General Court, guys, you got it exactly wrong. We said exactly the opposite the last time. We're the higher ranking court. So, the bigger guy wins over a smaller guy. Then the Court of Justice would still have to go into standing and likely say no, because if Latome has standing, then basically any European has standing to challenge any EU law all the time. And that is something that the judges would probably have to say, even though we don't want to say that, we would still have to say it because we would otherwise open the floodgates to the courts. And that is a bit the reason why we think it does not make sense to kind of go further up. But then back on our side, if we now bring a national challenge that would meant to then be referred to the Court of Justice at some point, we would usually not get a local judge to do that as long as that case is pending there. So it's a question of where you put, frankly, donated money, and if you put it to an efficient use or not. And right now, as long as there is a case pending there, it's probably not overly efficient to bring another challenge.
Okay, so not anytime soon is the short answer for the audience.
It's really a lawyer's answer in that sense. It depends, and it depends specifically on what La Tombe is now doing. So we'll see that, and we know in a couple of weeks really what's going to happen with an appeal or not.
Okay, to be continued. That's a perfectly suitable answer. Thank you, Max.
I think on
flies,
and perhaps because that's a data transfer between the Europe and the US, but we all know that the data certain companies collect, I wouldn't name names on this in this session, but is not only being flown into the US. They are being used elsewhere in countries where Europe don't have adequacy agreement. So, I mean, we are on the right slide here. I'm staring at it. Please, make sure that you have with your vendor, if they are not retaining the data in Europe or perhaps transferring the US, there's a high chance that the data is being accessed and transferred for other purposes elsewhere. So make sure that you have, the BCR, binding corporate rules to ensure the same level of, guardrails applied and standard contract clauses as well.
And if I want to add like two or three more blunt lines, because that's the NGO role, we do have these cases, especially around China now coming up. The last years, we always had the question, why don't you do anything about China and Russia? And the answer was there's usually hardly any data transfers to China and Russia. Russia definitely still not, but China is really now, I would say, a year, 2 years, where it now pops up more in reality in user contracts or in indirect contracts. And the first cases we had on that were mind-blowing in the sense it was like, oh, we signed SCCs, but we never looked at Chinese surveillance laws. And that is really a whole new ballpark of really looking into that. And I think to a certain extent for companies, also a question of, do you want to go through the same trouble we had with the US data transfers now another time around by outsourcing stuff to China? So we see that so far, I think European companies are a bit shy of it. We mainly see Chinese providers basically getting their data back home, so to say. We don't see outsourcing so much so far, but that's what we see in our litigation practice.
I think that's very insightful. I think it's true that we very often reduce data sovereignty to EU-US, but the truth is it's a broader and more global topic. Someone in the chat just wrote that there is going to be a new GDPR in Chile. So like privacy is expanding at a fast pace around the globe. So thanks for bringing that up, Christian. Great. So for the sake of time, I suggest we move to the next section. I think we covered a lot of interesting ground here. Next section was a discussion around data collection. Let me maybe explain a bit why we chose that theme. So we all know that data privacy starts by collecting data somewhere, and very often the piece of the privacy equation, which is collecting data, is overlooked in a way. Yet, as we can see as a professionals, it's seeing dramatic transformation these days. And one of the themes we'd like to discuss today is this idea that data collection is being transformed. Data collection on the internet by companies, by gatekeepers, is being transformed with the emergence and the rapid propagation of what we call server-side technologies. So a quick recap for those of you who are discovering that. It's a fascinating topic, but for a long time, data collection on the internet was happening in your browser, what we call client side, and more this data collection is transferred toward a server side data collection, which means a number of things. But first and foremost, that there is a lot of data collection going on that you no longer see as end users. It has also some key benefits for companies that do it that way in terms of performance. Less scripts on the page means faster loading times, better overall like metrics from a pure analytics standpoint. It also means that you get more control over the data you're collecting, and you increase the data quality. It also means that if done right, it's an opportunity to have better governance. No longer you have like pixels firing on your website that you were not aware of and that are flying data to countries you don't want to. And so these days are slowly coming to an end. But it has some very interesting and I would say transforming questions from a privacy standpoint, as there is a lot in the mix with this transformation. First, the question of gatekeepers, the likes of Google, Meta, who are the main data collector on the planet. There is a lot of drivers behind this move that are linked also to the position of powers that these companies have by owning browsers, by owning operating systems, and that essentially deprive companies from controlling what data is collected. And so, like server-side data collection is a way to kind of fight that. And then there is the overall idea that companies need to run businesses, and so they need to have full control over the way data is collected. So that's for the context. I'll start with you, Marie. Maybe like a broad question around Piano. How does Piano look at this data collection aspect from a company and solution standpoint? Maybe also how you see like this server-side transformation at Piano, and how do you help your clients towards doing that in a privacy-preserving way at Piano?
Yeah, I think server side, I think it's great. I don't think it's a panacea. I don't think it's a sort of silver bullet that we have. And as we say, with great power comes great responsibility. So that responsibility, the sort of regaining that control yourself as a brand or as a business from all sorts of tags happening almost without you knowing about it. So that control factor is fantastic. And brands are building that direct relationship with consumers. So I think it's absolutely right for the brands to have that control. But responsibility part is, the transparency, the fact that it is happening in a way behind screen from the server side rather than client side. It's not always, it's not easily visible. So we have that responsibility to bring that transparency to the fore. I think that's very important, and using all the consent mechanism, etc. We do see more and more customers moving to server side, and we obviously work with Didomi. Adding by Didomi is one of the popular server side capabilities, because when people think about server side, a lot of people still think that it's going to be expensive, it's going to be high maintenance. We need to put in our own resources to maintain that, etc. If you're doing it fully in-house, yes, but outside you can absolutely outsource certain part of that in great partnership with few companies. So we do encourage our customers to do go server side, because as you stated in the previous slide, the benefits enormous. The fact that you can have a much more visibility into your sort of site visits, etc. That's fantastic. We always, going back to that exemption side, again, you don't need to wait until that consent to happen. So make sure that, server side or not, make sure that consent. So I think it's your right to collect that aggregated data and leverage that to improve your website. So that making sure that the audience measurement happens, and from server side being transparent and collecting the right data based on the consent that users are accepting. I think that's a very important thing. And perhaps it's not particularly related to server side, but we've seen, latest ruling, which is very interesting, about GTM, one of the German administrative court, Hannover court, ruling that GTM requires consent. And this was an interesting for us as well, because many of our clients, and Roma, I hope you agree, many companies are actually relying on GTM to trigger the content management platform. And if GTM requires consent, and if all the exemption that I mentioned, as well as all the other valid measurements that you want to collect, is sitting behind Google Tag Manager or any tag manager for that matter, then it just destroyed the whole audit process that I mentioned earlier. So I think, for me, we would recommend our customers to make sure there's a separation of church and the state. Consent mechanism kicks in first, and then triggering the tag management to manage the right, triggering the right tags, etc. So I think that's an interesting point.
The order in which you execute things matter a lot with respect to privacy.
Absolutely.
And I agree with you. Like, server side is also an opportunity to do things really wrong from a privacy standpoint. In a very transparent way. So something that actually we are working on at Didomi by building this privacy preserving data collection and sharing platform that we have. We have started with the acquisition of a company called Addingwell, but that's for the advertising part of this. We now I'll stop there. Um, like taking a bit of a step back and looking at like the topic from a broader perspective, we have Max a very interesting initiative going on in Europe called Digital Omnibus, where there is this idea and desire to simplify regulations that have been established by Europe regulations that are heavily weighing on this data collection piece. So, like the intent, and I read here of the Digital Omnibus project is to, for the part that is related to data collection, reduce cookie consent fatigue, strengthen users' privacy rights online with clear and straightforward information and options for managing cookies, facilitate the use of cookies and other technologies for businesses for increased data availability. What's your take on that, Max? First on this Digital Omnibus initiative, and more broadly on server side, on this server side transformation of data collection on the internet.
I mean, on the omnibus, that's now the second omnibus going around. The first one was the one where, for privacy purposes, we changed Article 30 slightly, which we also had a study on DPOs on what really takes time, what really, costs energy for business versus what actually provides privacy protections. And you can basically map that. So we started to map this, like, how much time do you spend on something in compliance and how much does it bother business versus how much privacy does it give you? And you have certain things that actually don't bother business as much and gives you a lot of protection versus some that doesn't give you much protection and actually is a lot of work. And what I saw with these omnibus approaches was that work was probably not done in the first step. So we have a bit of a political feeling of we just want to do something with less bureaucracy, but without really having probably the proper evidence and approach to say, okay, what really is our spent on stuff that doesn't make sense? What is our spent on stuff that does make sense? And I think that is a bit of a problem that I generally have with this omnibus idea of just, let's say, change articles all over 100 different laws, because it usually leads to not being properly conceptual. Like, you don't look at GDPR and say, what can we streamline in the GDPR? It's more like, let's change one article here and another one there, which overall doesn't really limit the burden and doesn't really change the problem. Now, specifically on the upcoming one, they do have obviously Article 5.3 of the e-privacy kind of in the focus. If we look at what the previous e-privacy directive reforms were going towards, there is one thing that I think is probably rather agreeable, is that there may be more legal basis for just processing of cookies for, anonymous statistics, security purposes, the topics that in the GDPR world, we would definitely raise legitimate interest, to kind of add that to the e-privacy world. There is one idea of moving e-privacy into the GDPR and thereby have all the 6 legal bases available, so to say. I have a bit of a problem with that intellectually or conceptually, because e-privacy is usually based on Article 7 of the Charter, which is the right to confidentiality and communication. And that's usually a much higher threshold. Like, to interfere with communication is usually higher threshold than CCTV or anything else we do under GDPR. So to just move it over would fundamentally drop down the communication protections we have in Europe. And interestingly, also for businesses. I mean, Article 7 of the Charter applies to legal persons as well. Like, you cannot phone tap a business just because it's a business, while the GDPR does not apply to legal persons, for example. So suddenly there wouldn't be any protection for business communication if it's terminal equipment that gets intercepted. So I'm not sure about that approach that some of the tracking industry pushes for, because they are eyeing legitimate interest. But that has a lot of consequences for a lot of other business situations. So I'm not sure if that's realistic. But and I think the third question then is, if we say, okay, we can probably get the typical, website performance questions and so on, which for most businesses that don't do online advertisement, about only 1/3 of European businesses have ever done online advertisement, which means, ordering an advertisement on Facebook, let alone ever really tracking on your own website. So if you look at the 2/3 that don't do any of that, that would be probably easy to say, okay, let's whitelist the statistics, blah, 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 and thereby not need any consent on these pages anymore. That could get you kind of this warning sign of a consent a bit more, to say you really just see that banner anymore on websites that do something more with your data. I think that would be useful. And the other question that's upcoming and rolling around is the question if we get this whole signal debate another time around. So obviously, the idea of that California put into law, I think last week, to have
Absolutely, that was my next topic.
There
So
you go. I
thanks
didn't
for
even know
nice
that.
segue, because
Perfect.
there is this idea that is emerging, that we might see some like centralized like consent mechanism at the browser level. Some people are pushing for it, and California, as well as Connecticut, and another state that I don't recall, but that is here on my notes, Colorado. Sorry.
I was just to say, usually it's Colorado.
yeah. These are the three. Yes. Have like made that signal mandatory, so for companies to respect when the signal is present.
I think the technical approach makes a lot of sense. It's basically a header signal saying I want this or that, which for the non-technical people in the audience, we have header signals, for example, that my browser says I use German as the main language, and the website knows to kind of send me German back. And no one ever types language selections anymore. Otherwise, we would have what I would call, I don't know, language selections fatigue, because we would get asked this question on each website. We just do that automatically in the background. The problem with American signals is different. The Americans don't have an approach of, for example, opt-in and opt-out. So we have objections, consent, withdrawal of consent. So we already have 3 different rights we need to signal. And we have different purposes. So I think we also need to be able to allow companies to kind of define the purposes freely, because as a nonprofit organization, I may have the purpose of finding donations, which is usually not in the IB purposes as a typical list. So you probably need a more open definition here. But the fundamental idea of signaling that digitally does make sense after all. And I think that would be a discussion that is quite interesting, if that could happen or not happen. From a CMP perspective, you would still basically have the same CMP. You would just basically then not have the cookie banner be shown, but instead the signal works in the background, which also last bit there could be interesting from a user interaction perspective. Like, you would then not have another banner that disrupts. It just basically would happen in the background, and the exchange would happen digitally. And that's quite interesting if that would come up, because that could factor all these things in. Because last bit, I think consent will not going to get rid of, because in reality, a lot of people criticize consent, and there is legitimate criticism around it, but it's part of the Charter. It's in Article 8 of the Charter of Fundamental Rights. So unless we change the Charter of Fundamental Rights, consent is going to be there. So the question is, how can we make it more efficient for everybody that exchanges that? And that would be quite interesting.
What is required to make that like great vision happen is some kind of a global open standard around around privacy. I mean, global, at least in Europe, for GDPR. But we need, as you said, like to describe in a way that is digitally readable, like computer readable, all purposes, and all the nuances that come with the way like GDPR has framed data processing. So something that my concern is not happening in the American tech companies. That's not their way of looking at this problem. And as it was asked, I think in the first question, I think the cultural difference in the way we approach privacy with American companies is likely to create some friction here,
Yeah.
and as a result, unfortunately, like to make this vision like complex to put to life. Even though again, like standardization, I think would help a great way if we manage to to standardize in the computer readable way all data processing going on the internet. So something fairly complex, but that could be achieved.
We looked into that, if I may, for a second. We looked into that. We called it advanced data protection control like 5 or 6 years ago with a university to be like, how could that be done? And one benefit is in Europe that basically the controller can define the purposes. So it would be always the controller saying, first, that's my 5 or 6 purposes that I put forward. And in practice, they would probably be the IAB defined purposes for most controllers. They would just, from the transparency consent framework, get the requests in and then forward them on the other side. And that could be a situation where the individual website or the CMP running the website basically just relays these text bits that we already have in the TCF. But
that's funny that was the solution, because one thing that is like for sure is that IAB like static purposes are heavily criticized by everyone, including by most of our clients, because they don't feel they are correctly represented. So they don't feel these purposes correctly describe what they are actually doing with data. And so that's where I think like standard will always like hit a wall, because there are nuances, and to put everyone in the same box is just basically killing the nuances of the internet. And that's my main concern with this approach, though I agree with you from a pure like standard standpoint. That's the solution. That's the elegant solution to the consent fatigue problem, and that's what we would need.
To go back to the kind of omnibus question, I think what's interesting is what's going to come after these first 2 omnibuses, because now there's the next thing about the digital fitness test, which is all like very nice headlines, but what does it really mean? And that could be the question for next year or so, if there is actually like any deeper change to the GDPR. So we also engaged in that to a certain extent, because I think what would be interesting is to kind of have we called it like GDPR light and like heavy, so to say, because right now we have this one size fits all. And there could be an approach to say, okay, there must be different rules for the Googles and whatnot than for your kindergarten around the corner, which in 2016, when we basically had the GDPR coming in, the industry was very much pushing for like the one size fits all. But now, obviously, in practice, that also shows to be a bit complicated. And that's all the discussions that we'll see probably next year. Which one of these ideas ever get traction, if there is going to be a reform anyways, or, we'll see all of that, I assume.
Cool. Thank you, Max. Let's probably move on to the last topic, and a very original one, as you can see on the screen, which is artificial intelligence. Now, obviously, we can't have a proper webinar without discussing artificial intelligence. I think we have here like a kind of a unique perspective on artificial intelligence, which is basically focused on the intersection between the privacy and artificial intelligence, and more precisely, we'll try to zoom onto like very specific elements of this intersection. I don't need to share much context here with the audience, because you like AI is everywhere, and we can measure that clearly as professionals, and that impacts us in our work, in the way our companies operate, and there is a lot to be said. Just like first, like an anecdote for Max, because I saw that like this afternoon before the webinar. Do you know that there has been over 100 deaths in the Alps since June 1st, and that the best explanation that for this uptick is that people start preparing their treks and hikes on ChatGPT. So that's how scary it is. Like I think we are just starting to measure the impact of ChatGPT and the likes of it on our lives. Joke aside, what with your perspective, what are the key legal and ethical challenges that you see with AI in a privacy context, Max?
Yeah, on my end. So we right now look mainly at the training stage, and I have to say we have our own little AI computer to play around with stuff, and we're generally like, how can we use it well? But what's quite interesting for us is what happened with the regulators around AI training, where basically it's kind of a total sellout to be like, okay, anything is now a legitimate interest. There is no limit on what you have to do before you ingest data. I think the peak example was like the social media companies now saying, we now also take all your social media profiles, including, I think a week or two ago that LinkedIn said, oh, we're now doing this too, which is quite interesting. And we see more like output problems of that as well, that we basically have people saying, oh, my name is actually in that thing. It does identify me. It can tell me I'm living in that street or like in that city, and I have a very specific name, and it then makes up other shit. So we have one case, for example, of a Norwegian guy that was identified, but at the same time said that he killed his kids. And we have other cases where it's like, you abused your children sexually, really stuff that for a lot of people is not funny anymore. Even though like in abstract terms, it's bullshit, but like for people individually, it really means a lot. And that is interesting where we are surprised about the regulators so far, that there is this kind of, okay, we'll just do legitimate interest and whatnot. Now, as far as we know, there was a lot of political pressure on the regulators to say that. Basically, if you question that AI training can be somehow, not always be legal, then there may be political backlash in the sense of we're going to open up the GDPR and just write it in there. So that is at least a rumors you hear. How much that's true, you never know. But the end result may be that a lot of these companies rely on that now and generate a lot of these things that are questionable from an ethical perspective, but also once this hits the court of justice from a legal perspective. So we now look at a very simple question, for example, necessity of that data for training. Like, is it really necessary to take all the social media data? And if you then see, the results that Meta produces with that social media data are worse than OpenAI without the social media data, then you wonder how much, for example, even the necessary test under legitimate interest is met here, let alone that, data minimization, even in the training phase where you have to say, do you really need that personalized? Can you anonymize it before the training, etc.? So there's a lot of these questions that are brewing up, and it's quite interesting for these very big companies that do like whole models, how much risk appetite there is right now. So, I mean, a lot of that means millions of people that potentially have a damages claim against you. And that segues nicely to what we work on right now a lot is collective redress in Europe, like class actions. We now have, since a year, 1.5 years, the European class action law, and I cannot tell too much publicly, but it is now brewing up. Like, there are more and more cases that can be a very legitimate class action, combined with damages, which oftentimes per person is, 200 euros, 500 euros, whatnot. But once you have 1 million people, we have the first cases where we calculate if we can even bring the class action, because the case would be much, much bigger than the money that that company has. So you literally run the risk of bankruptcy when you file, because the company may go bankrupt before you can even bring the case. In a lot of these like data broker situations, for example, where these companies oftentimes are rather small in reality. And that is
maybe it's a good way to clean up the market, I guess.
Yeah, I mean, we're not sure if we want to do that. My personal perfect idea is that the regulator regulates and we therefore don't have damages later to collect. But if that doesn't happen, that there is a lot of risk brewing up here, which may not be for AI usage of companies that just use the model in the end, but some of the implementations are a bit, let's say, very progressive in positive terms.
So you think it's just these companies putting the problem under the carpet and just
right now, I think
appetite for risk, or is it just like ignorance, or have they planned for this like massive backfire that will come on the road?
My personal impression, but I'm not an expert on like that part of the company side. Maybe other people in the call are much more of an expert on this. Is that we now have this arms race for AI, which, I mean, is bullshit anyways. It's a bit like, we don't have an arms race for industrialization. The British came up with that first. Everybody else learned it 5 years later. We all got industrialized at some point. So I don't see the race. It's probably more of a marathon in reality. But this narrative of the race basically says we're going to throw more money at that, just do more and more and more. There is the question if financially all of that in the end is going to pay off. I mean, there's the question about an AI bubble bursting, all of that. I'm not an expert on that. But in that whole hype, so to say, the question is if anybody bothers about the GDPR. And the answer is probably no. But that means that risk is building up somewhere in the basement. And that could be quite interesting if we say, for example, this will hit the Court of Justice the next 1 or 2 years, probably. And I would assume the Court of Justice says, even if they say legitimate interest, fine. They would usually say, but not everything. They would usually say, but you have to minimize the data, you have to, anonymize what's possible, blah, 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 blah. It would probably have a long list of requirements to say that's a legitimate interest. And now you have hundreds of companies that have not done any of that, which means, potential damages in reality. And that is quite an interesting scenario that we're thinking about right now on where this may end up in 2-3 years. And having done litigation, you oftentimes realize how, you already say stuff when the hype begins and be like, guys, hold on a second. And then 5 years later, you realize that's what happened in the end. So you learn that some of these, worries are also materializing later. That all being said, not meaning don't use AI. Like, we're definitely on the world of, this is an interesting technology, but we're in a question of, can you just throw everything into it and not bother anymore, or not worry anymore?
I would say there are companies that are doing AI probably right and in a responsible way, and I think that's a nice
and I hope that pays off for all of them in
Marie
the
and
end.
Fenner, because having witnessed like your latest product demo, you're probably doing AI right and putting AI at the right position in your company. So I'm supporting Max's statement. AI can be positive in a way. It's just privacy shouldn't come as an afterthought.
I think it's an interesting, Max, when you said it's an AI race. We've taken it as an AI, not piano, but in our world, we've taken it as an AI race. And as a result, I mean, the latest study from MIT said 95-97% of AI projects failed. Not failed in a horrendous way, but failed to actually deliver business bottom line. It's because it's not well thought through. It's not aligned in business purposes. So everybody jumps in the bandwagon and start doing all sorts of chatbots and things without actually aligning to business objective. As a result, when you measure ROI, there's no ROI, and there's a failure. I don't think it's a failure. You should try it, etc. So we have had that race, and we're still having that race. But I think it's important that we align all these AI projects, because it's expensive. It's not cheap. To the business purposes. And from Piano perspective, because we are a data company, we handle gazillion data points for thousands of clients around the world. All the safeguards, guardrails that we put around the data that we collect on behalf of our clients for the GDPR purposes, HIPAA purposes, or I know that there were folks talking about new Chilean privacy law, which is very similar to GDPR as well. All of that guardrails we put in our data applies to all the AI projects that we do. So what I mean by that, so we have, our analytics product is very much powered by AI, at least one big part of it, to help our clients access the data easily without actually having full data literacy or full analytics literacy. But to do that, we need to use LLMs, and we've made a very, very conscious decision on what are the projects that we need to work on. So if it is about democratizing the data, giving our clients access to sort of natural language processing queries and whatnot, let's make sure, because we're using our clients' data, let's make sure we guarantee the data safety, we guarantee data residency. So if it concerns our European customers, data don't leave Europe, even when we use our AI products. And same is true if it is our US client, the data will remain in the US and not contaminated with the rest as well. And when we select LLMs, we have a RAG retrieval-based stuff, as well as accessing the data. And RAG, that's well, yes, we use ChatGPT, but because that's only based on our knowledge base, which is publicly available information, it never contains our clients' data. So we made this conscious decision, and we absolutely want to make sure that we are guaranteeing that all the guardrails that we promise to our customers. But the other point is, we guarantee all of that. But then, we talk about shadow AI economy, where Marie sitting in Piano, we have our own Claude, corporate agreement controlled LLM that we can use. But if Marie actually start using ChatGPT and start putting our code or some client information or PII, then that's something that is definitely no. But it's not something that Piano can control, because it happens outside our Piano environment that we safely provide to our clients. So I think it's very important as a business that we all educate our colleagues within the business to use the AI, this powerful tool, in the right way. in the safe environment, and then it will really power your decisions. The other thing is that transparency aspect, ethical concerns of using AI. So ethical in the sense that it can be the bias, the machine algorithm can have bias, and human bias can be actually amplified in AI space. So we need to make sure that that bias is not embedded in AI. But for us, from data company, the transparency aspect, we're churning a lot of data. We're using different algorithms, propensity modeling, etc. We need to make sure when we give the answers to a very simple question, such as what was our ROI from the marketing event campaigns that we did in the past 2 years or 2 months, we need to give that transparency, how we calculated it, because we're now actively advising. We're not only giving the metrics and reporting, we're giving AI-based insights as well. So and recommending next best action. When you do that, you have to make sure you are being transparent on how you calculate this data. Where does this recommendation come from, based on what factual data that you have? So that transparency, bringing that forward, when our clients are using it directly in the user interface is vital for us.
Thank you, Marie. I think it opens a lot of questions for me, and I think it's also a nice segue to the next section, which is AI agents. And I'll attack this with the question of responsibility, because as you framed it, there is an unanswered question with AI: who is responsible? and I think that's the big topic that is missing in most AI discussion. And I would like to frame this AI agent. Last discussion, we have a couple of minutes around this notion of responsibility. A simple example is, as a user, I'll mandate an AI agent to do something on my behalf on the internet, and this AI agent will interact with a company AI agent, meeting his needs. An AI transaction will happen in the middle, with a lot of transfer or potential transfer of personal data. Where does privacy keep existing in this world, and who is going to assume responsibility in case things go wrong? So tough question, I know, but I really wanted to throw it, and maybe as food for thought for the audience. But for you, Max, are you thinking about these new problems that are slowly emerging or emerging fast, actually? And what's your take on this?
I mean, some of it, to be frank, I still feel is a bit dystopian, and let's see if people actually do that. I mean, I had these discussions about someone getting their AI Tinder to talk to the AI of another Tinder user to then figure out if they want to have a date or not, which is but anyways,
that's just hilarious. But,
I think some of that, usually you would just, as a lawyer, go back to good old law, and the thing is, if you have any tool that is under your power, then towards the other side, you're liable for what that tool does. No matter if that tool is an animal, if that tool is an employee, or if that tool is a technical tool. That's the good old rules of who is liable for what. That being said, you then have the question of who provides that tool, and that provider may be liable inside of that transaction. And there you then get into the question of some of the litigation we have of, for example, that tool producing stuff that is not GDPR compliant, typically just wrong answers on an individual. And then you have to kind of separate these outside and inside relationships. And I think that's rather easy to solve, to be frank. And I think that's also one thing to highlight. A lot of these GDPR rules, we sometimes have these discussions about, that's the old GDPR and the new AI, and obviously that doesn't go together. I don't think that's true, in the sense, if you read when these principles were written in the 90s and in the 80s before I was born, that was usually, if you read the authors from the time, was all the data is going to go into the big algorithm. That big algorithm is going to do weird things we all don't understand anymore. And then it will make weird decisions that we cannot understand anymore. That's the reason why we need correction of the data. That's the reason why we need access to the data. That's the reason why we need transparency, blah, blah, blah. And what they described back then is very close to what we now call AI. Like the idea they had of this is going to be possible at some point is very much what we now call AI. So I think a lot of these rights that we have actually fit that situation perfectly, to say if an AI algorithm generates wrong information about you, that's the reason why you have a right to correction or deletion if it's wrong. The big question now is how do we implement that? And that can also be done by, for example, fine-tuning of an AI algorithm to say you have to fine-tune that wrong information out of it, so to say. And I think that is where the disconnect is still a bit there, to say, oh, we're just not going to do it. So we had some calls, for example, lobby calls at the European level, where a lot of these AI companies were basically saying, oh, we can't correct it. And I was like, if you can't correct it, then you can't use it because you're liable for that. But once you press them a bit, obviously the answer was, yes, we could fine tune stuff out, but that would cost money. And I was like, yeah, if you make money with it, you probably have to invest the money to also fix the problems. And I think that may be the answer to a lot of these issues, that if you just bit by bit go through these elements and these puzzle pieces, most of it does have an answer. And then there will be certain elements where we may need to adapt the law here and there to make it fit. But largely, I think we do have answers on that. And also the other way around, on using some of this AI, does perfectly work under legitimate interest for certain elements, does perfectly work under consent for other elements. It's not really that this is all new. I think it's just like the facts are so hard to comprehend for lawyers. And once you don't understand how it works, it's really hard as a lawyer to apply the law properly. And there, I think, is a and the lack. Also on our side, for example, we still really struggle with some AI elements of how technically that really works, so that we can say, okay, that's reasonable, that's not. I think we're probably a bit deeper in the weeds than others sometimes, but it's still a challenge right now to kind of get the facts together, much more than with a good old database.
Kind of a black box problem, like
yeah,
no one really knows.
I think for someone for a young thing, Max, born, I don't know, did you say in the 80s? I was already born then. But when we talk about AI, I mean, because we work with clients in various industries, like especially tech, publishing, or even retail environment. First, some of us are worried about does that mean we have to pivot our business model? Where we used to rely on eyeballs and people actually shopping on our sites, they're now going away and happening with an agent-to-agent relationship. And we've seen the new business model popping up, like a Cloudflare offering paper crawl type of thing. So we're facing that with our clients. We're doing our best to advise our clients, looking at data, measuring who's what sort of bots and LLMs are visiting, etc. So we have that big problem that we need to face. Hopefully we'll turn that into opportunity rather than sort of businesses going down. But we are already talking about agent to agent, agentic commerce relationship, where people are actually not visiting publisher side, visiting retailer side. They're actually asking their agent to go and find the best deal for my holiday next month. So when that happens, who's the data controller? Who's the data processor? It becomes quite murky, and who's responsible for what? So I don't have answers, unfortunately, for today, but it's an interesting time.
It is. I think it's a great conclusion. We've had a lot of questions on the question tab. Unfortunately, we won't be able to address a lot of these questions. Hopefully, like you got some answers and some nuggets out of this conversation. We are almost at time, so I still have to thank every one of you in the audience, and first and foremost, both you, Max and Marie, for attending this session and this very interesting discussion. We touched on a lot of different topics, which tells you how deep and profound privacy is for a lot of aspects of our lives. Thank you again. So it was the second session we had all together. See you next year for the third, I would say, hopefully. If by then we haven't been replaced by some AI. I can assure you that this webinar was prepared without AI and presented by actual human beings. So I hope you enjoyed it. Thanks a lot, and thanks for the great participation that we had in both the chat and the questions. Have a good day, everyone, and we'll see you next time. Bye-bye.
Bye there.
Thanks.